Welcome, everyone, and good afternoon. My name is Anna Black. I am the Associate for the Time's Up Legal Defense Fund. And the Time's Up Legal Defense Fund and Legal Network for Gender Equity are proud to bring you this webinar focusing on legal advocacy for workers affected by COVID-19. Specifically, this webinar will address rights and remedies available to workers under the Families First Coronavirus Response Act, or the FFCRA, and related laws. And we know that COVID-19 is particularly impacting workers who are caring for themselves and family members. And we appreciate that many of you are getting questions from workers facing problems accessing paid sick days and paid leave. We recently expanded the scope of our legal network for gender equity to allow workers to seek legal advice about these issues, and we were humbled by how so many attorneys in our legal network immediately accepted our invitation to be connected with those workers. So we're very grateful to all of the attorneys who volunteer with our legal network for gender equity for all that they do to combat sex discrimination in the workplace, and for taking the time today also to learn more about how to help workers navigate the added challenges of working in this moment. I'd like to extend a thank you to our excellent presenters for their time in developing this webinar and their presentations today. Thank you also to the law firm of Holwell, Schuster, and Goldberg, LLP, for working with us to offer CLE credit for this webinar. On that note of CLE, I will be announcing course numbers throughout the webinar, so please stay alert for those. And the form is attached to the email, the reminder email that you all received yesterday. Now, I'm not going to take the time to describe the many accomplishments of our presenters, but a speaker list, including brief biographies, is included in the CLE materials that were distributed to registrants yesterday in advance of today's webinar. Lastly, before we begin, we will have time for questions from the audience at the end of the webinar. During the presentation, if you are an attendee, please keep yourself muted. You may send questions and comments to the presenters by using the chat function or the Q&A function, and we'll do our best to address the questions you send during the Q&A at the end of the webinar. So that all said, I would like to go ahead and start the webinar. So we'll be starting with Carol Joyner, and I'm going to go ahead and give Carol control.
Thanks so much, Anna. And to all of you who've joined the call today, especially thanks to the National Women's Law Center, Time's Up Legal Defense Fund, and the important work that you've been doing for so long now. And the other partners who have joined this call. It's been great to get to know those of you who I don't know. I'm so pleased to be part of this important discussion on how best to support workers who are experiencing a multitude of hardships related to COVID-19. I'm trying to figure out how to move the slide forward. Okay, excellent. Again, really appreciate this opportunity. What I want to say before I even get started too far into this conversation is that, there are a number of trauma-related effects that working people and their families are experiencing, whether they are personally exposed to the coronavirus, are family members providing caregiving to people who are sick, are elderly people just trying hard to stay healthy in this environment, or the vast category of workers on the front lines of this pandemic. There's fear, there's anxiety, there's stress, there's depression, are all at a high level operating right now in our society. And affecting so many people, from the littlest ones to the elderly. And so this conversation is really important to understand how best to provide support for everyone who's involved. So we'll learn the details of the Family First Corona Response Act and the related laws that were passed from Molly and other folks in this presentation. But what we need to know and understand up front is that when the Congress passed The laws, a significant part of the population was excluded. Most concerning is that it excluded healthcare and essential workers, those who actually need it the most. And so what Family Values at Work did, and we're a network, if I didn't say this, Family Values at Work is a network of 27 state coalitions. We've been moving paid family leave and paid sick days policies for the last 16 years on state and now on a federal level. And when the law first passed, we worked with our state partners, but also many of our national partners to create this blueprint for our network for Know Your Rights. We wanted to quickly figure out who is eligible, who was excluded, who could potentially fall through the cracks. The blueprint includes details of the FFCRA, the CARES Act, the emergency state paid sick days bills, and a decision flow chart, and much, much more. And so all of these materials, I think, are included in what Anna has sent out to you. Because of the weak enforcement associated with the law, we couldn't really offer the same level of protection or support as we do for many of the state laws that have passed. We did, however, ask individuals to tell us via email what they were experiencing, and this is what we learned. I'm having trouble suddenly advancing this. It tested well, but there, thank you. So the major responses we got from folks who contacted us was that they either exhausted all their options, or they thought they had exhausted all their options and they were near panic, or they were navigating the best possible option for themselves. That means that they maybe had one or two options and couldn't figure out how they would benefit the most. Others were still working despite desperately needing time off, either because they were homeschooling someone, or because a sick family member needed care, or for other reasons. And then there were a bunch of issues related to retaliation by employers and confusion about the law. Next slide, if someone's moving them for me. Looks like they are. Okay, excellent, thank you. And so in the first two instances, the first two bullets here, those were situations where we really couldn't help people. Both in the case of the Pennsylvania worker, the size of the Department of Corrections being 500 or more employees, and the fact that they were a healthcare worker basically took them out of running of any of these policies and support. And then we received several inquiries from undocumented workers or those who had other than US citizenship about whether or not they should even try to get these policies because they were very fearful of being exposed or possibly deported. In the case of the AT&T caller in the third bullet, we were, somewhat happy to be able to inform them after we did a little bit of research that AT&T had actually expanded their number of PTO days so that they were able to find another 2 weeks or 10 days or in order to really quickly figure out how to manage the fact that they were going to be helping their child with remote learning while they themselves worked. 10 days is not a lot of time, particularly not in COVID time. And then finally, the last person who contacted us on this list and said that they were out of options was actually someone who had a really great option. She was a worker from California, and for the first time made use of the California State Paid Leave Fund for caregiving. And so that person actually had a big option that they were not aware of. For the most part, though, I would say, we were not able to help people, mainly because of the size of people who were just excluded from the law. Next slide, please. And so another category, navigating paid sick days, paid family leave, unemployment insurance, but also factoring in the benefits that they have on the job, as well as whether or not there were any state paid sick days or paid family leave policies. All of that had to be, really people were trying to consider that. And sometimes it just became a math game, right? Those who had two jobs, maybe one they just did on the side, were able to realize, well, for this job, I can actually claim paid leave for caregiving. And they've used that as the way to get through this crisis, and are probably still using it. For some, it was just simple math, like what's better? How do I get more money right now for my family? Is it UI? Is it figuring out how to get paid sick days or paid family leave if I qualify? So that was just really a process of talking to people and helping them figure out what's in their best circumstance. And just because some people realize is just because they had sufficient funding for the moment, that did not necessarily mean it was the best case scenario for them, because they also needed to stay attached to the workforce ultimately. Next slide. Then the hardest, one of the hardest situations for people, and we know people like this, we read about them, we may know them personally, I have them in my family, those who are still working. The majority of workers across the country are still working, either remotely or as essential workers out in the streets, right? The most difficult situations are those that, like healthcare workers or people exposed to the illness every day and having to go into work. According to the Economic Policy Institute, 55.2 million essential workers, of the 55 million essential workers, the majority are women, people of color, and those without a college degree. Meaning that for that last population, they're earning lower wages, and for them, work is completely important for them to be able to put food on the table, roof over their heads. Many of those folks are also single parents. The dilemma on the screen is very typical. The nursing home worker in constant fear of their own exposure or bringing that particular illness, the coronavirus, home to their family members. It's the same concern that's driving the voices of teachers across this country as school systems try to figure out whether or not they're going to open or provide remote learning options. Next slide.
Carol, can you see the next slide? Uh-oh, one moment. It seems like we might not be able to hear Carol for a moment. Let me take a second to see if this is something that it seems like we've lost Carol for a moment. Let's take a pause here. Would any of the other panelists like to continue? Let's see, maybe we can move forward with Molly's presentation and return once Carol has come back. Molly, are you comfortable with that?
Sure.
Okay, great. So let me move forward to your pages.
Thank you so much, Anna. Hopefully everyone can hear me. So for those of you who don't know, my name is Molly Williamson. I'm Director of Paid Leave at A Better Balance. For those of you who aren't familiar with us, we're a national legal advocacy organization based in New York City, but with a presence around the country, working to ensure the ability of working people to care for themselves and their families. As you'll hear more about, we've done a lot of work around paid leave laws, both FFCRA and laws around the country. I also just want to highlight as a resource, not only for callers, but also for yourselves, I know my colleague from Work-Life Law will do later. We also, through our free and confidential legal hotline, which the number is at the end, do also advise not only on the leave laws that we're about to talk about today, but also things like pregnancy accommodation, breastfeeding rights in the workplace, and caregiver discrimination, in case that's helpful in any of these circumstances. Today, I'm going to talk to you a little bit about sort of a basic overview of Families First, and then just briefly touch on some other leave laws that may be helpful to some of the folks you're talking to. So the Families First Coronavirus Response Act, or FFCRA, was passed in March and provides two kinds of paid leave under the law, which we'll talk about in a minute. The law was set up to be effective on April 1st. There's some complications around that you'll hear more about in a couple of presenters. The big picture thing that I want to highlight for folks in thinking about the FFCRA is that for the time being, FFCRA is temporary. Unless Congress acts to extend it, the FFCRA's leave provisions will sunset at the end of this calendar year. So for the time being, all of the federal protections we're about to talk about will cease to be in effect at the end of 2020. My slides are going too fast for me. Let's see, there we are. Apologies. So there's two kinds of leave under the FFCRA. The first of which I'm going to call emergency paid sick leave. The second of which I'm going to call emergency FMLA. And I think as we go along, just keep in mind that there are these two different kinds of leave under the FFCRA, and to some extent they overlap, which can be a little bit confusing. The first type is emergency paid sick leave. Emergency paid sick leave under the FFCRA in general applies to public agencies regardless of size, so public sector workers, and to private entities that employ fewer than 500 employees. And this is where we get to all of those workers who were excluded, as Carol was talking about. I do want to stress that last part just because it is so unusual. So in the private sector, the FFCRA only applies to employers with fewer than 500 employees. Those with more than 500 employees are automatically excluded. In addition, there's a few key potential exceptions that employers can choose to claim. The first is the potential exception for healthcare providers. There's been some flux around the definition in response to recent litigation that you'll hear more about in a couple presenters. Employers can also claim an exception for emergency responders. And employers with fewer than 50 employees are not automatically carved out, but can voluntarily choose to claim an exception only for the childcare purposes of the law and only under specific circumstances. The criteria are set out in the Department of Labor regulations, but are essentially set up to mean providing the leave would cause you to go out of business. I think there's a misconception that the FFCRA does not apply to employers with 50 employees, and it's not really the case. There's a potential exception under very specific circumstances. Emergency sick leave provides leave to up to 80 hours. If you are a full-time worker, someone who works at least 40 hours per week for a single employer, you can take up to 80 hours of emergency paid sick time. If you're a part-time worker, you basically get a prorated amount that comes out to the average number of hours you work in a 2-week period. Unlike standard employer-provided sick time or sick time under state and local laws, this is not an accrual system. You get the full amount right up front, and it's available from the first day of employment. You can take emergency sick leave under the law for a combination of 5 purposes. These are fairly dense, so I'm going to summarize them as concisely as I can, but please do know that all of this is also in your materials. You can use this leave when you're unable to work or telework because you are, number 1, subject to a federal, state, or local quarantine or isolation order related to coronavirus. That includes if there's a shelter-in-place order that's preventing you from working or teleworking. You can use it if you've been advised by a healthcare provider to self-quarantine due to concerns related to coronavirus. That could include if your healthcare provider thinks you may have it, but could also include, for example, you have some kind of underlying health condition that makes you especially vulnerable or makes it especially dangerous for you, and your healthcare provider has advised you to self-quarantine. You can use the leave if you're experiencing symptoms of the virus and you're seeking a medical diagnosis. And then you can also use this leave for two purposes that are related to caring for someone else. The first is if you are caring for an individual who is subject to a federal, state, or local quarantine or isolation order, or who has been advised by a healthcare provider to self-quarantine due to concerns related to the virus. So for example, that could be if you're caring for a loved one who is immunocompromised and their health provider has advised them self-isolate and they need your care, that could be covered. You can also use this if you're caring for your child whose school or place of care has been closed or whose childcare provider is unavailable due to the virus. And I want to stress here that that applies for any covered parent who's in that situation. It doesn't necessarily need to be, doesn't at all need to be that your child is actually sick. This is just if you have a childcare need because your child's school or daycare is closed or their childcare provider is unavailable because of the crisis. If you're covered, you can take this leave. The amount of money that you receive under the law depends on the purpose for which you're taking leave. So if you could sort of mentally flip back to our last slide, if you're taking it for a purpose about your own health or safety, so those first three bullets, you receive 100% of your regular pay up to a cap of $511 per day or $5,110 total. If you're taking the leave to care for someone else or because of a school or daycare closure, so those last two bullets, you'll receive 2/3 of your regular pay up to a cap of $200 per day or $2,000 total. The asterisk there is just to note that for workers who typically make less than minimum wage, like tipped workers, there's a special provision to basically level them up to minimum wage. A couple of odds and ends just to be aware of. Again, this leave can be used immediately, regardless of length of employment. There's no probationary period or accrual system. Emergency sick leave can be used prior to any other available leave. Your employer can't force you to, for example, use your existing PTO first. And this law doesn't take away any existing rights you have. And then last, but certainly not least, and probably actually most, emergency sick leave is job protected for all covered employees. You're protected against retaliation. You have the right to continuation of your health insurance. I think that's critically important to stress, particularly in a CLE. To touch very briefly on enforcement, but just know that you're going to get a lot more information about advising workers from subsequent presenters. Emergency sick leave violations under the FFCRA are enforced as Fair Labor Standards Act minimum wage violations. That's the structure the statute sets up. And just like a minimum wage violation, there's both a private right of action and the option for administrative complaint with the Department of Labor. So now I'm going to switch gears to the other type of leave under the FFCRA. For the most part, the same workers are covered under both the emergency sick leave and the emergency FMLA provisions, with a couple of key exceptions. So first, while emergency sick leave applies to federal, state, and local government agencies, regardless of size, emergency FMLA only applies, for the most part, to state and local government agencies, regardless of size. Unfortunately, most federal employees are not covered for purposes of emergency FMLA, though they typically are covered for purposes of emergency sick leave. Again, that same 500 employee cap applies. So private entities that employ more than 500 employees are not covered. The other key difference in coverage between emergency paid sick leave and emergency FMLA is that for emergency FMLA, you need to have been employed with your employer, not worked, employed, for at least 30 days to qualify. Those same exceptions that we talked about with regards to emergency sick leave, healthcare providers, emergency responders, under specific circumstances for employers with fewer than 50 employees, those all still apply. I just want to stress here again, while this is part of the FMLA, when you're thinking about who's covered, think about what we're talking about right now, not regular FMLA coverage, because there just are two totally different coverage standards. So the emergency FMLA provisions of Families First essentially amended the FMLA to, in addition to providing special coverage requirements, include a new purpose, which the law calls public health emergency leave. Public health emergency leave is available when you're unable to work due to the need to care for a child whose school or place of care has been closed or whose child care provider is unavailable due to coronavirus. And if that sounds familiar, it ought to, because it was the last bullet on the slide listing the purposes for emergency paid sick leave. So there is this one overlapping purpose. I think in general, the way to think about the relationship between the two types of leave is that emergency paid sick leave is available for a shorter duration, a maximum of effectively 2 weeks, but covers many more purposes. Whereas emergency FMLA is available for a longer period, up to 12 weeks, but only covers this one specific purpose. And I apologize for those of you who can hear my toddler in the background. Under emergency FMLA provisions, covered employees can take up to 12 weeks of emergency FMLA leave. The first 2 weeks may be unpaid, but the remaining 10 weeks must be paid at 2/3 of the worker's regular pay. Again, the caveat for sub-minimum wage workers, up to a cap of $200 per day or $10,000 total. The way to think about that first 2 weeks unpaid provision is that the idea was that workers could use their emergency paid sick leave to essentially cover that gap in unpaid time, with the result that those taking leave for childcare purposes, assuming they're covered by both provisions, could get up to 12 weeks paid through overlapping the two provisions. So I think that's the thing to keep in mind here, is that emergency FMLA by itself only guarantees 10 weeks of payment, but a worker may be able to essentially combine the two kinds of leave to get up to 12 weeks paid in total. Because emergency FMLA is situated in the FMLA, it provides some pretty familiar kinds of employment protections for those who are familiar with the FMLA. In general, emergency FMLA does provide the right to reinstatement. So those who take emergency FMLA are entitled to get their job or an equivalent job back following leave. However, there is a limited exception under the law, which says that employers with fewer than 25 employees are not required to affirmatively reinstate employees under specific conditions. Those are further fleshed out in the regulations. There's specific both procedural requirements and reasons the job is not available. So just know it's not automatic, but the law does apply differently with regards to reinstatement based on employer size. All EFMLA covered employees are protected against retaliation, again, just like regular FMLA, and all EFMLA covered employees are entitled to continuation of employer provided health insurance while they're on leave, again, just like regular FMLA. How emergency FMLA rights are enforced depends on the size of the employer. For employers with fewer than 50 employees, the only remedy available is a Department of Labor administrative complaint. For employers with 50 or more employees, that administrative complaint process is still available, but there is also a private right of action using the regular FMLA setup. So essentially, whether an employer is covered for regular FMLA or not determines what type of enforcement is available. And just to touch very briefly on this, because I think it is really important contextually, particularly in thinking about how to advise workers about talking to their employers. Subject to certain requirements, under the FFCRA, employers can be reimbursed for the full amount that they've paid for emergency sick leave or emergency FMLA through refundable advanceable tax credits up to the caps. So another way to think about this is that while the law does say covered employers have to pay employees, they're essentially just fronting the money with the idea that the federal government will fully reimburse them for the amount they're providing. So it shouldn't really end up being money out of employers' pockets, which I think is a really powerful point in advising employees and how to effectively advocate for themselves. I'm going to skip over this slide because we have another presentation coming a few presenters down that'll go into more detail about the impact of recent litigation. And now I just want to very briefly highlight a couple of other kinds of laws that might provide other relevant leave rights that could be helpful to workers who either are left out of FFCRA or the FFCRA isn't meeting their needs. First, the FMLA. So for employees who are covered by the FMLA, they may be able to use regular FMLA for COVID-related purposes, whether that's you're recovering from your own COVID or COVID-related serious health condition, or caring for a family member with a COVID or COVID-related serious health condition. The one thing I'll note here is that if someone is taking emergency FMLA for that childcare purpose, those 12 weeks do come out of the regular FMLA 12-week bucket. So for example, if someone used the full 12 weeks of emergency FMLA for childcare purposes, that's their 12 weeks for FMLA for the calendar year. So if they have a subsequent unrelated need for regular FMLA, unfortunately, they may have maxed out their time. And the reverse could also be true. You could have used all of your FMLA time for a regular FMLA purpose, and that's going to affect how much time you'll have available for emergency FMLA. Carol noted a little bit of this earlier. You should also know that many states and cities have passed their own emergency leave policies. Many of these were specifically designed to fill in the gaps of the FFCRA, such as coverage of employers who have more than 500 employees. You have in your materials a PDF of a Better Balances tracker of these laws. You also should have the link to the live version of the tracker on our website, which we're constantly updating to help people have the most up-to-date information on where there are state and local emergency protections that may offer additional or complementary rights to FFCRA. More broadly, 13 states and over 20 cities and counties have also passed permanent paid sick time laws that provide protections beyond the emergency. These laws can offer important additional protections, which may be helpful to people who FFCRA doesn't meet their needs or they're not covered. The one thing I do want to stress here that I think folks may not be aware of is that many state and local permanent paid sick time laws include specific provisions allowing workers to use this leave if there's a school closure due to a declared public health emergency, even if their child is not actually sick, which may be helpful to workers in these circumstances. You can find more information about that in your materials. We also have detailed information about school closure provisions on our website. Carol actually gave a great example of exactly this circumstance with the California worker in her presentation. So for those who are dealing with extended health or caregiving needs, so if there's some kind of ongoing health need from contracting the virus, for example, state paid family and medical leave laws may offer additional protections or benefits. 8 states and DC have passed these laws, most of which are now providing benefits. Most recently, DC started just last month. Massachusetts will start in January, and several other states are already providing benefits. And again, lots more information in your packet. And with that, I just want to highlight, you can find a lot more information about all of the kinds of laws we've talked about today, including a lot more detail about the kinds of state and local laws I brushed over very quickly on our website at abetterbalance.org. I've also put my contact information and the contact information for our hotline on the screen, and we're very happy to answer additional questions, to speak to workers, to do whatever is going to be helpful in relation to this. And with that, I'm going to turn it back over to Anna.
Thank you so much, Molly. I'm going to pause here for a moment to read off the first course code for the CLE. So I will be repeating this code twice, and then we'll move on. In addition, I've heard from a number of you in the chat that you may not have received the materials beforehand. We can send that to you all after this presentation as well. So with that, I'm going to read the code. So the first of these codes is going to be NWLC 0818. So that's NWLC 0818. All right, and so with that, I'm going to pass it over to, I believe it's to Ed and Franny.
Yes, this is Franny Ryan, and with me is my partner, Ed Sweeney. We're having difficulty moving the slides. Do we have control of the slides, Anna?
You need to unmute it all day.
Okay. As I said, this is Franny Ryan. I'm with my law partner, Ed Sweeney. The name of our firm is Wissenich & Sweeney, and we are located in the suburbs of Philadelphia, and we practice work law. We help workers in all sorts of litigation matters with their employers, and we are not only law partners, but we've been married for 27 years. So what we are going to cover here is current cases, challenges, and emerging issues. We're going to talk about a couple of cases that we are actively litigating now, and we're going to talk about a very important decision that just came down a few weeks ago from a district court in New York. In the materials, if you haven't received them already, you'll be getting them. We're going to include the final rule on the FFCRA that the Department of Labor passed. We're including the opinion from the District Court of New York in the recent New York versus DOL case. And we're including select parts of a legal brief that we recently filed in one of our FFCRA cases that highlights a lot of emerging issues. Starting with the Department of Labor challenged by the Attorney General of New York. Shortly after the Department of Labor issued its final rule in this matter in early April of 2020, there was a bit of an outcry among the plaintiffs' bar and others who were concerned that the rule really restricted the impact of the FFCRA unduly. And the state of New York, in the person of the Attorney General of New York, went and did something about it. She filed suit in federal court against the Department of Labor, and she asked the court to strike down 4 of the more onerous and probably unlawful parts of the Department of Labor's regulation. So the first was the work availability requirement. And what the Department of Labor did in the regulation is they said, even if you're otherwise eligible for leave under the Emergency Paid Leave Act and the Emergency Unpaid Family Medical Leave Act, you are not an eligible employee if your employer does not have work available for you. And this obviously guts the law because the whole business climate in the country was turned upside down because of the COVID-19 pandemic. And many businesses were topsy-turvy. They didn't know from one day to the next whether they had work. And so this requirement was the biggest gutting of the law in the regulation. The second requirement that the New York Attorney General went after was the definition of healthcare provider. In the regulation, the Department of Labor defined healthcare provider for the purpose of people who were excluded from the law. Remember, the law says employers of healthcare providers can exclude them from all the applications of the law. They get no leave at all. And what the regulation did was define healthcare provider by reference to anyone who is employed by a long list of entities, including any doctor's office, hospital, healthcare center, long-term care center, laboratories. It was just a very long list. So if you work for one of these entities, even if you're not a healthcare provider, you get no coverage under the FFCRA according to the Department of Labor's rules. And the third rule that they went after is, for the first time ever, the Department of Labor is saying that employers need to consent to intermittent leave under the FFCRA. As we know, we've operated under the Family and Medical Leave Act with intermittent leave provisions for many years. There's never been an employer consent requirement. And for all of us who've litigated in this field and done HR work in this field, you know, employers don't really like intermittent leave. It's difficult and expensive to administer. And if the employers could veto any intermittent leave requirement, they would love that. In this rule, just plucked out of the blue, the Department of Labor gave them that right, at least for FFCRA leave. And the New York Attorney General sued to strike that down. And the fourth requirement in the rules that the New York Attorney General sought to strike down is that the rule says the documentation requirements must be met prior to taking leave. And that's another new one. We never had a requirement under prior laws regarding family medical leave that the employer had to come up with all of the documentation prior to even beginning leave. The legal regime up to date has been that if there's some documentation missing, the employer is supposed to ask for it and the employee is given a reasonable amount of time to provide it. So the district court very quickly heard this case and rendered a decision. And the District Court in New York knocked down all 4 of these regulatory requirements. They refused to enforce the work availability requirement. And the analogy that the court used is it's as though if a school teacher were on leave and there were a snow day, does that mean she's no longer on leave because there's no work available? Well, that's just silly. They said any employee who's eligible for this can take it regardless of whether the employer has work available on that particular day. The court also knocked down the definition of healthcare worker in the regulation because the Family Medical Leave Act actually has a definition, and it says that the Secretary of Labor can designate people who are capable of providing healthcare services. That's the wording in the statute. Capable of providing healthcare services. Those people can be designated by the Secretary as healthcare providers. And the English professor at the college, which happens to have a hospital attached to it, is not a healthcare provider, the court ruled. The third regulation that they knocked down is the intermittent leave. The court said it just makes no sense to require employer consent to intermittent leave. That fails the Chevron deference analysis because it's just not reasonable. And of course, the court also knocked down the requirement that employees provide documents prior to taking leave. So that's the gist of the Attorney General of New York versus Department of Labor decision. It's only one district court in the Southern District of New York. It's a very well-written and very persuasive opinion. We certainly hope that it's upheld by the Second Circuit and that it's applied in the same way by the other courts around the country. Ed, did you have anything to contribute on the healthcare provider issue, or should we wait till we get to one of our cases?
We'll just wait.
Okay. The two cases we're going to talk about are Stephanie Jones versus Eastern Airlines and Paul Simone versus HARBORVIEW. So Stephanie Jones is a woman who was recruited by Eastern Airlines, which is located in Chester County, Pennsylvania, their headquarters. She was recruited from her home out west, I believe it was in Texas or Arizona, to come here in October of 2019 and take a job at a director level. She was very highly compensated, very high level employee. Stephanie is also a single mother whose son was enrolled in the schools in Chester County, Pennsylvania. And in March, the schools shut down. They issued a notice saying we're not going to have school for 2 weeks or maybe longer. Stephanie's mother was visiting from Texas and displaying COVID-19 symptoms. And just as an aside, it happens that Stephanie was the only Black high-level employee at Eastern Airlines. So what happened to Stephanie Jones in March 2020? When the COVID-19 epidemic hit, most, if not all, of the Eastern employees who could work from home worked from home. They telecommuted. And Stephanie was among that group. She was fully able to do all of her job duties from home using her phones, her computer, the web, and everything else, texting. After the FFCRA was passed, which happened on March 18th, 2020, Stephanie began asking her employer for flexibility to take care of her son because she was telecommuting from home and her son was at home attempting to do virtual schooling with his school. In conversations with the HR leader at her workplace and other people, eventually they told her that she was eligible to take leave of absence. But they didn't really respond to her request for flexibility to work from home and not just take a total leave. Ultimately, on March 24th, Stephanie sent a detailed, lengthy email to the president of her company and the HR lead, specifically mentioning family medical leave and the FFCRA, and asking for leave and asking what information they wanted her to provide to get that leave. There was never another word discussed except for a hostile response to that email. And on March 27th, Eastern terminated Stephanie's employment. She never got a response to her request for leave, and she didn't get a very clear explanation of why she was terminated. So Stephanie came to us, and we filed suit on her behalf in federal court in the Eastern District of Pennsylvania. Here are the challenges in Stephanie's suit. First of all, when the Pennsylvania schools started shutting down, there was no legal protection for parents, as just in other parts of the country. In Pennsylvania, there was no legal protection at all for parents whose schools shut down. Many parents had to work from home or not work because of the governor's shutdown order. Unfortunately, airlines were exempted from our Pennsylvania governor's shutdown order, so Stephanie didn't have that legal out. So the FFCRA is passed on March 18th, but when does it take effect? Are different parts effective on different dates? These were all open questions back in March. Another open question is whether workers could take intermittent leave under the FFCRA while telecommuting. The regulations eventually were issued later in April, but in March, nobody knew what the law was going to be. So in Stephanie Jones's case, the defendant, Eastern Airlines, immediately moved to dismiss the case and said the law did not take effect until April 1st. And so she's out of court. She's out of luck. She has no protection. So we are currently litigating that issue in the federal court here. And here are some of the highlight issues for how do you determine what the effective date of the FFCRA is. The statute itself did not contain an express effective date. Like most employment law statutes that have been passed by Congress over the years, most of those statutes have an express effective date. one statute might say this law shall take effect 1 year after enactment, 2 years after enactment. Some of them were 6 months after enactment. This statute, the FFCRA, said it shall take effect not later than 15 days after the enactment. And no one is really sure what that means. I've not seen it in any other statute's effective date. The background rule, according to our Supreme Court precedent, is that every law is effective upon enactment unless Congress clearly sets a different prospective date, a different effective date, presumably prospective. So what happened with the Department of Labor is on April 1st, it issued a Q&A saying that the paid leave provisions of the FFCRA are effective on April 1st. And then on April 6th, the DOL issued its rule under the Administrative Procedures Act. And that said eligible employees may take expanded Family Medical Leave Act during the period April 1 through December 31. Again, nothing in the rule says what the effective date of the statute is. There is currently no statement by Congress or rule issued by the Secretary of Labor that says what the effective date of the statute is. So we're arguing that at most, the Secretary's rule means that the leave provisions take effect April 1st. Eastern Airlines says that essentially employers have a license to retaliate before April 1st because the law wasn't effective until April 1st. And their second argument is that Stephanie Jones had only been with them since October. She did not have 12 months of service. And recall that the FFCRA shortened that time of service requirement to 30 days. The question is, was that shortening effective March 18th when the law was passed? Was it effective some other date, April 1st, perhaps? So we are arguing in Stephanie Jones's case that first she was protected from retaliation and interference by the Family Medical Leave Act of 1993. She expressly requested leave. And the FFCRA actually amended the Family Medical Leave Act to tack on a new protected type of leave, the caring for your child whose school is closed. But they didn't enact in March of 2020 a new retaliation or interference provision. She was protected by the existing anti-retaliation and anti-interference provisions of the old law. Second, we're arguing she was protected from retaliation under the FLSA. The FFCRA actually amended the Fair Labor Standards Act to say that certain actions were also subject to penalty under the FLSA. So the FLSA has a very broad anti-retaliation provision that's been in effect, of course, for decades. And we're arguing that she was protected by that from retaliation. Third, we're arguing that the anti-retaliation provisions in the Emergency Sick Leave Act were effective March 18th and protected her from termination because there's no other effective date that Congress or the Secretary of Labor has given for those anti-retaliation provisions. And so under Supreme Court law, they must have been effective upon enactment of March 18th. And finally, we're arguing that the time and service requirement was shortened to 30 days effective March 18th by the law because there is, again, there's no rule and there's no statute that says a different effective date for that 30-day time and service provision. We have fully briefed these matters. We're waiting for a decision from the court in the Eastern District of Pennsylvania, and it'll be interesting to see what they do. I'm going to turn this over to Ed to talk about another FFCRA case that we're currently handling.
Hi, I'm Ed Sweeney, and I have the great pleasure to be married to Franny. This is a case where a person was a maintenance supervisor at a facility that did rehab and nursing care for the elderly. He was, his name's Paul Simone, and the nursing entity is HARBORVIEW. It's, I believe, in Bucks County. At the time of this case, there was a COVID-19 infection, widespread throughout the facility. He asked for an N95 mask and was denied. His significant other at home was susceptible to COVID because of prior health concerns, and he was very nervous about that. So he asked for the N95 mask and was turned down. Subsequently, he was told, he told his supervisor that he had COVID and was terminated 1 or 2 days
Sorry.
later. Mr. Simone got sick, right? And he told his supervisor that he was sick, and he had the symptoms, and he was terminated before he said, I actually had COVID, but the testing came back, and he texted him that after his termination that he got COVID. He was willing, however, when he had COVID symptoms, to come in to work, right, in case of emergencies, right? His supervisor, unfortunately, in our allegation, indicates that that Mr. Simone resigned at some time, and that just wasn't the truth, according to our client. Now, the major challenges in this case is the statutory exception for healthcare workers. But as the New York decision says, that healthcare workers has a specific meaning which goes back to the FMLA, right? So I would leave that to the people in this seminar, the lawyers who are looking to follow that up in the FMLA definition. It's one targeted at healthcare, not for people who are, as we assert, non-healthcare workers who are basically supplementary workers. The DOL rule expanded that definition beyond what the statute was, which was cross-referenced in the FFCRA as the New York decision meant, right? Now, the Secretary's authority has authority and has Chevron deference, but basically this fails the first part of the Chevron test, right? As the court, as the statute is not silent or ambiguous. I mean, it specifically says what the definition of healthcare worker is by reference. I mean, one of the issues will be, what does it mean for an employer to elect to exclude?
Should we talk a little bit, just briefly, on the elect to exclude? This is a reference to the part of the statute which says that employers may elect to exclude healthcare workers. It doesn't say that it's automatic. It's really not clear what elect to exclude means. Mr. Simone was never informed that he was excluded from the FFCRA or that he was a healthcare provider under the FFCRA. So one issue in that case, and I'm sure in many other cases, what must an employer do to elect to exclude someone? Can they wait until the lawsuit happens and then say, oh, we elect to exclude you from the provisions of the law? Or do they have to warn them in advance?
Our position is they have to give notice up front, or the notice to exclude is not effective.
And on that, we'll turn it over to Anna and the next presentation.
Wonderful. Thank you so much. Liz Morris will be continuing with the next couple of slides.
Thanks, Anna. Thanks to Time's Up for having me and to everyone for being here. I'm Liz Morris. I'm the Deputy Director at the Center for Work-Life Law, which is a national advocacy and research organization that's housed at the University of California, Hastings Law in San Francisco. One of the key areas of focus for work-life law is employment discrimination against family caregivers and pregnant and breastfeeding people, also sometimes called family responsibilities discrimination, or FRD. Unfortunately, family caregivers and especially mothers are facing a wave of discrimination right now because of COVID-19, as we've been hearing. So far in this webinar, we've heard a lot about FFCRA and litigation, which has all been wonderful. And so now we're going to shift gears a little and talk about counseling workers before litigation arises, and hopefully with the goal of seeking immediate relief for workers without the need to resort to litigation. And I commend all of you for agreeing to provide counseling to folks who have questions around leave. So let me see if I can advance the slide. Okay. Great. So as you've been learning, questions about leave typically come during coronavirus from 3 categories of folks. The first are people with caregiving responsibilities. So that may be child care, elder care, a family member with a disability or a health issue, including COVID-19. It may include people with health concerns who need leave. Molly, would you mind muting yourself, please? It may be people with health concerns who need leave. So that could be a worker who's at high risk if they were to get COVID. So somebody who's pregnant, folks with diabetes, asthma, obesity, et cetera. It could be somebody who has a high-risk family or household member who's worried about bringing the virus home with them and exposing that person. Also, folks we've spoken with have just general concerns about risk and potentially unsafe working conditions. For some reason, I no longer have control of the slides, although I did just a moment ago. Anna?
Sorry, I was on mute. Let me take a second. Let me see if I can do that over again. Do you want to try it now?
Okay. There we go. Thank you. And then the final category of folks that you may hear from with questions about leave include people out of work or facing job loss. That may be people facing layoff or furlough or on layoff or furlough, and also folks who are facing termination, often because their leave has expired or for asking for leave. So now that we see who might be calling, I want to go through 12 tips that we came up with at the Center for Work-Life Law to how to handle these calls. And all of this is based on the Center for Work-Life Law's COVID-19 legal helpline that's been operating since April. So first, as we've been learning, there are some major coverage gaps and some other potential shortcomings of the FFCRA. So the first few tips that I have for you involve examining all legal angles. And I'm going to go through quite a bit right now to flag for you all of the different legal claims and laws that you may rely on when somebody calls you with a leave-related question. But please know that I've provided a lot more detail and links to further resources in your materials. And also, my colleagues and I at the Center for Work-Life Law are happy to chat with you about any of this more in depth if you're interested. So the first tip is to consider leave options beyond the FFCRA. So first, we heard from Molly to check regularly for new COVID-19 emergency leave laws. So these are sort of the gap fillers. And what I really want to emphasize is check regularly. These are passing all the time, and just because there wasn't one last week doesn't mean that there won't be one this week. Same thing is true about state and local paid sick leave laws that Molly touched on. These are passing regularly and can be used by people who need COVID-related leave. So Google works great for finding those. And A Better Balance also has an excellent website cataloging them. Consider leave that may be taken as an ADA accommodation for folks who have ADA qualifying disabilities. So someone needs leave and they have cancer or diabetes or heart condition or severe anxiety that's flared up because of COVID. Those folks may be eligible under the ADA for leave. Also consider leave as an accommodation for pregnancy. If somebody calls because they're pregnant and they want leave, the Pregnancy Discrimination Act or related state laws may be able to help that person. And as Molly mentioned, the FMLA and state level equivalents are available. COVID-19 can be a serious medical condition in bad cases, and entitling a worker to take leave for their own case of COVID or to care for someone else with COVID. And then also, we have had some success in persuading employers to provide folks with leave by arguing that the worker is needed to provide psychological comfort and reassurance for their family member who has a serious medical condition. So the spouse, parent, or child has compromised immune system, and so having the worker stay home on FMLA leave would allow them, to provide psychological comfort and reassurance. And there you see the reg. I'm not sure if this argument would hold up in court, but at least it would be an uphill battle. But we've had success with it in persuading employers in writing, demand type letters. The next tip in examining all legal angles is to ask whether an accommodation is actually better for the worker than taking leave. And the reasons why an accommodation may be better is that leave, there's a few reasons. Leave is typically limited in duration, especially statutorily provided leave like FFCRA, capped at 12 weeks. And when that runs out, I wish that the crisis was going to be over in 12 weeks, but it's definitely not. So what do they do then? Also, leave is typically unpaid or partially paid, and so it's unaffordable for many people. And then finally, not with FFCRA, but with other types of leave, like administrative leave, folks may lose their health insurance when they're out. So ask whether an accommodation is actually better. Accommodations that may help during a pandemic include remote work, higher quality PPE like masks, face shields, goggles, plexiglass, HEPA filters, temporary transfer to alternate position, modification of job duties, modified schedule or reduced hours, alternate work location, work uniform changes, administrative leave. And I think, as always with reasonable accommodations, the key is just to sort of try to be creative with what you can come up with for that worker in their workplace. So, how do you know if somebody's entitled to a reasonable accommodation? As a practical matter, how do you get that information? What we typically do is we ask folks, do you have any health conditions when we speak with them on our helpline? And so, we can sort of probe whether somebody has an ADA qualifying disability like diabetes, heart condition, cancer, immunocompromised state. And I would add, thanks to Carol for pointing this out at the outset, it's really important. Some folks with anxiety or depression may be having flare-ups, and so those could constitute ADA disabilities as well. Also, pregnancy and breastfeeding may entitle someone to an accommodation. P.S. folks are still entitled to receive safe space for expressing breast milk even during coronavirus. In some states, obesity qualifies as a disability entitling somebody to an accommodation, although not at the federal level, is my understanding. Note that there are no accommodation entitlements for seniors. Your age alone does not entitle you to an accommodation, so it's really important to ask for medical conditions when you speak with somebody who is worried about returning to work because of their age, because oftentimes they do have an underlying condition that will entitle them to an accommodation. And one thing that we've been doing is leveraging the right to take leave for an accommodation. Perhaps I could have stated that a little more clearly. Basically, when people have a right to take leave, we've used that as a bargaining chip to get them an accommodation for the reasons I mentioned earlier, why they may not want to be on leave. And this can be sort of a win-win for the employer and the employee. The employer doesn't want to lose the person for 12 weeks or whatever the case may be, and the employee wants to keep working for the reasons I mentioned. And so they can sort of negotiate, I won't go on leave, but I need this accommodation. And that we've seen success with that in the past. Okay, tip number 3 for examining all legal angles. When the worker feels unsafe, explore whether the employer is complying with health and safety guidelines. So typically government issued health and safety guidelines are not enforceable, except for in Virginia, apparently, which is wonderful. But they can still be used to apply pressure to employers, in demand letters. So the CDC has business guidelines, business safety guidelines. Federal and state OSHAs have return to work guidelines, and then state and local health departments often have guidelines as well and are willing to become involved. You can consider filing a complaint to a government agency to try and get the employer to shape up, although we have been hearing that that is not typically effective, unfortunately. And there are some limited private claims you can make around health and safety, and you can check out the handout that I provided in your materials for more information on that. The handout, by the way, is like 10 pages of all of this in more detail. So if something I say here is too brief to make sense, please check that out. Okay, and this is the final tip in examining all legal angles, and I think that it's a really important one. And that is to probe whether discrimination played a role in any decision, in the decision to not grant someone leave, in the decision to not provide an accommodation, in the decision of who to put out on a furlough and who to allow to continue working. So what we're seeing is that mothers, fathers, and other caregivers are being pushed out of the workplace and are being treated less favorably than non-caregivers. And there are a few legal avenues to pursue here. The first is family responsibilities discrimination, or FRD, or caregiver discrimination, however you want to call them, statutes. And these are basically laws that prohibit discrimination based on family responsibilities or based on caregiver status. And so there's actually 185 FRD laws around the country. Now, we don't have one at the federal level yet, but at a couple of states and more localities do have these laws, including New York City. With these laws, there's no administrative exhaustion requirement. Typically, there are uncapped damages and attorney's fees. And so also because these laws haven't been heavily litigated, there's sort of a clean slate. And so a lot of opportunity to advance the law in a positive direction, and the sky's the limit. You may also consider more traditional route, Title VII of the Civil Rights Act, and the state level sex discrimination laws. And so there's a lot more in the handout, but I just want to point out a stereotyping theory here for making a disparate treatment claim, which is really relevant during the pandemic. So we'll see, basically, the stereotyping theory can apply to mothers or fathers, but on different grounds. So for mothers, we may see that there's some sort of adverse employment action, like, for example, not selecting a mother to come back from furlough and selecting other coworkers first on the grounds that, well, this person is a mother, they have lots of caregiving responsibilities, really they should be taking care of their kids, and they're not going to really have time to do their job effectively, so let's not call them back. That would constitute illegal sex discrimination. Similarly with fathers, if there's a father who asks for a flexible work arrangement, like working different hours of the day, that's being given to other mothers in the workplace, and the employer says, yeah, no, you're the father, shouldn't your wife be doing that? That's not your job is to work and make money. That would be sort of a proscriptive stereotype about what the father is supposed to be doing. So those can serve as a good basis for Title VII disparate treatment claims. Also keep in mind the ADA, the Americans with Disabilities Act. Of course, there's no right to receive an accommodation, for caregiving, but caregivers can make associational claims. So, for example, if there is a worker who has a sister with a severe disability and requires, a lot of care, and the sister's the facility where the sister normally goes during the days is closed because of coronavirus, and the employer knows about that and decides that that worker isn't going to be able to do their job duties, not based on reality, but based on just assumptions, and decides to put that person on leave, then they may have an associational claim. And by the way, the person with whom the worker is associated does not have to be family. I use sister as an example, but it can really be anybody with a disability that they are associated with. We're seeing that people who are at greater health risk may be pushed out when the employer wants to avoid liability. So we're seeing folks with disabilities just being pushed out, not called back, and of course that may violate the Americans with Disabilities Act. We're seeing seniors being pushed out, treated differently because the employer is worried about risk, and that may violate the Age Discrimination in Employment Act when folks are 40 plus. And then we're seeing pregnant and breastfeeding workers also being pushed out and treated differently, and that may violate the Pregnancy Discrimination Act or the Break Time for Nursing Mothers Law. We also want to consider whether retaliation has played a role. We have been seeing folks retaliated against unlawfully for asking for leave, asking for an accommodation, or complaining about health and safety. Another theory to consider is wrongful discharge in violation of public policy. So what we're seeing is folks are being asked, this was a little bit more earlier on, but who knows what course the pandemic is going to take. We're seeing people being asked to come back to work actually in violation of stay-at-home orders, and the person is, doesn't want to go back, and they're told if they don't come back, they'll be fired. So that may be a wrongful discharge in violation of public policy. And then finally, as always, you want to consider race, national origin, and other protected classifications. I think particularly with regard to Asian Americans during the pandemic, always, consider if protected classification has played a role in the decision or adverse action. Okay, that was a lot. That's sort of examining all legal avenues, crash course in what legal options are available. So now I'm going to talk a little bit about looking for helpers. So first, tip number 5, rely on labor unions. Most collective bargaining agreements require compliance with federal, state, and local law. And so a quick way to get relief for somebody who calls you is to find out if they're in a union. And we've even offered to speak with union officials about, how they might go about filing a grievance based on a legal violation. Also, coach healthcare provider gatekeepers. And by healthcare provider gatekeepers, I'm referring to the fact that healthcare providers are often or always the ones who are responsible for writing work accommodation notes, for certifying workers for leave. So they're sort of the gatekeepers for leave and accommodation. And oftentimes they don't know what's reasonable. They're worried about asking for something that is unreasonable or could be potentially unlawful. Sometimes they're worried about that. And so, of course, you want to take into account attorney-client privilege, and you may have to communicate through your client, but you can communicate with provider about what is reasonable. So, for example, you don't want a note that says, my patient cannot be exposed to any risk of coronavirus, unless that is really true, because if it's, if it's an in-person job, that's just not possible, and so the person is going to be sent out on leave or even potentially fired. Instead, you could try, my patient must have access to appropriate PPE, including goggles. And remember that medical recommendations can be amended later if necessary. And by the way, when we're talking about pregnancy and breastfeeding accommodations, you can use Work-Life Law's note writing guidance for pregnancy and breastfeeding available at pregnantatwork.org. Pregnant at Work is an online resource center that provides tools and educational materials about accommodating pregnant women at work, and it includes tools for healthcare providers for writing these notes, also for lawyers and for workers themselves. Okay. So the next set of tips has to do with actually counseling the worker when they give you a call. And the first tip is to clearly explain their legal rights in plain language, as always, but be comfortable with the novelty and uncertainty presented by COVID-19. So there's a lot changing. We've heard about it earlier in the webinar. DOL issues regulations, and a court in New York finds that they were not authorized to issue various of those, rules. And we're applying old laws in really novel contexts. So, we just explain to the worker, this is a bit unsettled, but we're going to, take the position that is most favorable to you. And then also, please keep in mind that some people are going through the most difficult time in their lives right now, as Carol noted. And so please, be patient with people, be kind, because folks are going through a lot. Tip number 8 is to discuss the potential for retaliation and strategies to avoid it. This one's really important. The way we usually frame it to folks is that, retaliation is illegal. Your employer's not supposed to do it. It's a violation of the law, but there's no guarantees that your employer will not do it. Of course, we'll do everything that we can to help you if your employer retaliates, but there's no guarantees. And ultimately, it's the worker who decides whether to take that risk. One thing you can do that is really helpful is strategize with the worker about how to frame requests that they have or complaints that they want to make, so that it can be sort of phrased and presented in the way that's least likely to ruffle feathers. Talk about what message to use, whom to speak with, and in what order. That can be really helpful for folks. Of course, the National Labor Relations Act, Section 7, protects concerted worker activity for mutual aid or protection, even when workers are not in a union, so long as they act in concert with another employee. So what this basically means is that if someone has, an issue they want to raise about the workplace, perhaps a work and safety issue with the employer, they should go with somebody else to, act in concert with another employee, so that they have additional protection from retaliation. Want to advise people to keep notes and memorialize agreements with the employer. Like, for example, if they're given some sort of extended administrative leave, this is helpful to avoid retaliation, to have it all in writing, but it's also, of course, helpful to tee up for litigation if necessary. Tip number 9 is also really important, and that's to inform about unemployment insurance and pandemic unemployment assistance and flag appeal deadlines. So it's really common in our experience for employees to assume, often incorrectly, that they're not eligible for unemployment benefits. They don't realize that they're eligible when they call us on the helpline. So your job is to share the basics and encourage them to apply when they're out of work. And we have resources available in the handout I mentioned that sort of tell you what the basics are if you're not aware of that yet. For unemployment insurance, the rules differ from state to state, but many states have modified their suitable work requirements. They've relaxed requirements around availability and job searching. If none of that makes sense because you're not familiar with the UI system, check out the handout. But the bottom line is that folks are eligible now for UI where they would not have been in the past, so encourage them to apply. Pandemic Unemployment Assistance, or PUA, is a new income replacement program for those who are out of work or working less, who are not eligible for regular unemployment insurance, but who are out of work for reasons enumerated in the CARES Act. And this is administered by the same state agency that administers unemployment insurance. So folks who are eligible for this include independent contractors, which, that's remarkable, people with caregiving responsibilities, people with COVID-19 or caring for a patient, people at risk due to underlying health conditions, and many other enumerated reasons in the CARES Act. So the bottom line, again, is just apply. Unfortunately, there have been delays, significant delays, confusing administrative procedures, undocumented folks are ineligible, and there have been improper denials. These things are common nationwide. wide. So you can reach out to newly created clinics that are operating at legal aid orgs and law schools to get more information about what's actually happening on the ground in your state, and also perhaps for help with an appeal. But the key is to encourage folks to get their applications in ASAP to get the ball rolling, and I guess to expect delays. And you can help callers who are denied benefits. In other words, they have a letter saying they're not actually eligible for UI or PUA, to identify quick turnaround appeal deadlines. Some of these deadlines are short, like 15 days. And so you want to, the second you hear from somebody who has been denied, you want to check if they have an appeal deadline. Okay. Tip number 10 when you're counseling the worker is to inform about other lifelines. So 211 is an amazing service, mostly funded by United Way. You can call or call 211 from your phone and get sort of social service information concerning mental health, shelter and housing, utilities, crisis hotlines, supplemental nutrition programs, healthcare, and more, because folks are going to be coming to you with more than just an employment law question, because they're, most people that we speak with are really in crisis, and that affects all areas of their life. You can also contact local legal aid organizations for poverty law questions that are not related to the employment issues that you're dealing with. Tip number 11 is to offer something in writing. So I want to highlight for you the Center for Work-Life Law's fillable forms for requesting FFCRA leave. We have one for each of the reasons why somebody may want to take FFCRA leave, and the form can be filled out by the employee and includes all of the information the employer needs to claim the tax exemption and therefore to grant the leave. They're available in English and Spanish at www.worklifelaw.org. So if you have someone call who is eligible for FFCRA, they can simply fill out this form and bring it to their employer. Of course, you can always write letters from you to the employer, or ghostwrite letters for the employee to send on their own behalf. And for folks who are not comfortable disclosing to their employer that they've consulted a lawyer, you can provide basic education handouts. So, for example, something from the IRS or the DOL's website sort of explaining what the employer's legal obligations are can be super useful for the employee to bring to the employer. And then my final tip has to do with taking care of yourself. Tip number 12, access attorney support. So you can call the Center for Work-Life Law on caregiver discrimination or family responsibility discrimination matters. We can help with formulating claims and provide litigation support. We also operate an FRD attorney network that includes trainings and other useful FRD-related resources. And here's my name, Liz Morris, and my phone number, 415-565-4640. My colleagues and I are happy to speak with anybody about these claims. Remember, even if there's no legal remedy for the person you're speaking with, your listening ear helps. Just having somebody who cares and who listens and provides clear information can go a long way with workers in crisis. And then finally, this is really hard. The people that you're speaking with are going to be in crisis, and it can be challenging to speak with people who are going through so much, especially when many of us are going through our own stuff with COVID. So please take time for self-care. And with that, I'm going to turn it back over to Anna. Anna, if you're talking, you're on mute.
Oh, my apologies. I thought I had unmuted myself, but I suppose I did not. Carol, are you with us?
I am,
Wonderful.
surprisingly.
All right.
And I am just going to wrap this up. And I also want to give my apologies for my Wi-Fi going out at the end of my presentation, but I think you all got the gist of it. And so for us, okay. Anna, can you move the slide? It's not
Sure, let me, I gave control, but
Seem to have it. Okay, excellent. And so for us at Family Values at Work and many of our national partners and friends around the country, we know that there's more that really can be done by this nation in order to address the effects of the coronavirus. And so we had fairly quick action with FFCRA passing and then the CARES Act, but not much since then. And the folks that have been working on these policies have really been driving home the importance of the HEROES Act that was passed in the House of Representatives more than 2 months ago. This particular, we talked a lot about all the people who are excluded from this law. So the HEROES Act would close the loopholes and include all workers, just about all workers. There are some exclusions. They would expand the emergency paid sick and safe days through 2021. They would expand the emergency FFMLA, paid leave for school closures, but also expand it to include family and medical caregiving reasons like the FFMLA has historically. And also extend it through 2021. Both of those laws, paid sick and safe days and the paid leave law are under statute are going to sunset in December of 2020, December 31st, 2020. So this expands them another year because we have no idea, what we're dealing with this virus. And then it also makes all paid leave and paid sick and safe days permanent policies that are job protected. It maintains the UI policies through 2021 that Liz was just talking about, and it was also mentioned earlier. It gives funding for our city and state governments whose budgets are being depleted as a result of burdening a greater share of this coronavirus and the effects of it than the federal government. And it does many other things, increasing access to healthcare, including a robust child care assistance package. The hope is for $50 billion or more. That's a separate bill, but the goal, but in the HEROES Act, it's a smaller amount for child care. We know that. The goal is to get the HEROES Act passed, and it's, as I said, it's passed the House. Right now, nothing is moving with regard to these policies, and if you all are able to talk to people who you're counseling or yourself, if you're involved in advocacy of any sort, the goal is to call your senators and ask them to take action on the HEROES Act. Next slide. At Family Values at Work, we have a fairly robust network of people who are taking action in the streets and trying to move these policies forward in any way they can. And I'm going to recommend to you what we're asking them to do, which is to tweet at their senators to pass the HEROES Act, to plan virtual town halls or bring people together to do so, invite elected officials. If you can't get the senators to come on, then invite other folks who can speak on their behalf, or staff or other people. Some folks are doing house visits in our network, literally drive-bys, stopping at their houses with signs, placing op-eds on paid leave, on paid sick days, on covering all workers, on closing these loopholes, publishing blogs, and getting really creative with videos, art, and music. This is a time for, for everyone to step up. We are in unprecedented waters, and if I leave you with anything, I leave you with the idea that every single person makes a difference. Thank you so much for having us. Go to Family Values at Work. You'll find our COVID-19 blueprint. And thank you to all the people who've been on this call and listening, and also sharing information. Thank you.
All right, thank you so much, everyone. So that concludes the presentation. We'll have a brief Q&A section. I know that a number of you had some questions. So I'm going to stop sharing the screen, and we'll have our presenters, if they would like to join video, or if they prefer to stay just with names. Before we go into the Q&A, I also have one additional course code to read off. So again, I'll repeat this one twice. So that code is HSG 2020. Again, that's H for Harry, S for Sam, G for George, 2020. All right. And I've also been informed by Theo that for attendees, please email your completed attendance affirmation forms to jsanchez@hsgllp.com. And we'll also be sending an email to all attendees afterward as well. So with that, I'll open up the Q&A. So first, we have a question from Amanda Witten. That's how can an employee fight back if their employer claims can't afford the emergency FMLA coverage for childcare purposes, but the employee thinks that they can?
No, we could field that one. The answer is you need to hire a lawyer.
Great.
Sue them, in other words.
And let's see. Okay, so the next one we have is, what if an employer has a point system, or a point for every call out, and certain number of points equals adverse employment action, for example, suspension or termination, and COVID leave counts toward negative points? Could that be retaliation?
I think it can. I mean, basically under the FMLA, similarly, that if you take FMLA and they start taking points against you, that's illegal.
It's interference and retaliation, probably.
Would anybody else like to add?
I totally agree with that, and just want to also add one thing on the first question about the employer who claims that they can't afford to pay for the leave. Keep in mind when you're advocating for that person that the employer can be fully refunded through dollar for dollar tax credits for the leave that they're paying out, and so that sort of weakens the argument substantially.
Put me back. One of the things on the first one, as a practical matter, the employee often fears retaliation in that situation, and so you might want to approach the employer privately and sort of test the waters as to exactly, whether you think they're going to be retaliated against. In one situation, I actually negotiated more, the person would take on employment and basically would not make a big stink in the workplace that he was taking leave because of his problems with COVID, and it worked out. The employer, it was in the interest of the employer, not to have the guy infected at work, or to get really sick, and it was in his interest not to be there and to take on employment. That's it.
Wonderful. So let's take maybe 3 more questions. So the next one is, if an employee has been employed 30 days or more but less than 1 year, and their employer just have 50 or more employees, do they still have a private right of action?
The answer is that for the new types of leave provided in the FFCRA, yes, they do. For the traditional FEMLA leave reasons, you still need to have a year of service.
Great. Would anybody like to add to that? Okay. And then another question we have is, can an employer request a doctor's note prior to giving an employee emergency paid sick leave?
I can go ahead and answer that. No, they cannot request a doctor's note. Actually, DOL and IRS have listed out exactly what they can request, and whether it's before the leave or after the leave, they can't request a doctor's note. And the Center for Work-Life Law forms that are available at worklifelaw.org actually include all of the information that the employer can request. So the simplest thing would be to have the employee fill that out. Now, I will say that, you know, as a practical matter, you know, an employee may just give a doctor's note ultimately to, you know, save themselves from the strife with the employer. But technically, they are not required to provide that. And then the other part of this is whether they can, you know, request any documentation prior to giving the leave. And I think that what we heard from our colleagues, Ed and Franny, is that the DOL said that initially they could, but now a court in New York has said that they cannot. Is that right, Ed and Franny?
I think they can ask for things, but they can't deny leave until they get the documentation. So they're required to give the leave and then collect the information as they go along.
Great. So just one more question that we've just received. If a client has already exhausted unpaid FMLA leave for non-COVID reasons in the past 12 months, can they still take ESL or EFMLA for childcare reasons?
I'm happy to answer that if nobody else. So for the 2 weeks of the paid sick leave, whatever has happened with FMLA in the past is irrelevant. For the extended family and medical leave for child care purposes, that could be up to 12 weeks. What has happened in the past with FMLA is relevant. And so if they have exhausted their FMLA leave, you know, they had a baby or something like that, and they've exhausted the whole 12 weeks, then it may not be available for them when they need it for purposes of child care during the pandemic. However, I just want to flag for people who are not FMLA experts that it's not just the past 12 months. It's actually a 12-month period that has to be predetermined by the employer. And if there's 4 different ways to calculate the 12-month period, forward-looking, backward-looking, you can find it all in the regs. But sometimes employers will try to change what that 12-month period is, and you want to make sure that they're not doing that. There's actually a 60-day notice requirement for sort of announcing what the 12-month period is, and if there is no notice given, then it has to be calculated in the way that's most fair to the employee. So that's sort of a really technical thing. Happy to talk that through if you have this issue and call the Center for Work-Life Law.
And where that can matter is early in the year. If you took your 12 weeks in 2019 and then you need more leave in the first couple of months of 2020, you may be rotate on a calendar basis. And so you may be in luck if your employer has to treat you as a calendar basis. Meaning your leave entitlements start over on 1/1/20.
Yeah, and I think that some like educators at schools also start over at the beginning of the school year.
All right, Wonderful. Well, thank you all so much for our attendees for joining, and for our wonderful presenters. Thank you all so much for such an informative and well done presentation. This recording will be available on our website. We will send a link later on. But thank you again for joining, and wishing you all the very best until the next webinar.
Thank you, Anna.
Thank you.
Thank you. Take care.
Take care, everyone.
Thanks so much.